Welcome to Law Talk Today, a series devoted to bringing you informative and educational programs focused on issues of law, government, and community.
Good evening and welcome to Law Talk Today. My name is Mark Gruber and I'm your host. On this show every week we talk about issues in the law and people in the know. It's very interesting and I hope you stay tuned each week. We're on Wednesday evenings from 7:30 to 8. We will be interviewing people like officers with breathalyzer machines, battered women, judges, law clerks, you name it, and there's a lot of legal topics out there for us to handle. And we're going to bring them to you and have some good discussions, and it's educational. So stay tuned and enjoy the show. Tonight, we're going to be talking about wills, estates, powers of attorney, and trusts. And we have a young attorney with us who has a lot of experience in it. I want to introduce her, Susan Carlson, who's an attorney in Hamburg, New Jersey. Susan, welcome to the show.
Thank you, Mark. It's good to be here.
How about a little bit about your background?
Well, Mark, I went to law school out in Lansing, Michigan. After Lansing, I practiced for several years in Manhattan, joined a Bergen County firm in 2000. In 2002, I became a solo practitioner where I started to focus more on real estate and then estate planning, estate administration. And in 2008, I joined the law firm of Gruber, Colabella, Liuzza, and Williams with offices in Hamburg, where I'm located, as well as Hopatcong and Newton.
You've been writing wills for quite some time, I presume.
Pretty much so, yes.
Tell me, and tell our audience, do you need a will? Is it necessary?
Yes, a will, I believe, is absolutely necessary for a couple reasons. One of which, a will allows you, as the person who owns the property that is going to be left upon your death, to determine who the property goes to. Without a will, it goes according to what's called intestate succession, and there's a hierarchy which is codified by law, but you have no control over that.
And so without a will, the state statute governs the distribution of your estate.
Correct.
And to whom it will go.
That's correct.
Now, these laws of intestacy, they're somewhat complicated. Can you explain them so that everybody out there can understand it?
Well, essentially, without getting into too much detail, normally if you're married, your surviving spouse takes a great share. If you're married to a surviving spouse and you have children with that spouse would take the first 25% of the estate, so long as it's not less than $50,000 nor greater than $200,000, and then the spouse and the children split the rest, half and half. If you die without children but are married, it's the same scenario except for the spouse takes 3/4 of the estate, and if you have surviving parents, then the parents take 1/4, and of course if you die with no surviving parents, only a surviving spouse, he takes 100% no matter what, or she, as the case may be.
Well, I don't think I could repeat that. It's quite an involved scheme that the legislature has made, and I suppose that's one good reason why you should maybe go to an attorney and consult with an attorney. And I suppose if you wanted your estate to go that way, you wouldn't need a will, except who would govern the estate? Who would run the estate? Without a will, who gets appointed? What
happens is if somebody dies without a will, anybody who is their next of kin, and they like to get the closest next of kin. Obviously, if you're married, that's a spouse. If you're unmarried, it goes to parents and then brothers or sisters. And then what they would do is somebody there could be appointed as what they call the administrator if it's a male, or the administratrix if it's a female that is appointed. Obviously, let's assume you have no spouse, but you have 2 surviving parents. Then one of them would have to do what they call a renunciation, because both of them are equally entitled to be the administrator of the estate. The renunciation process is one says, you know what, I will step aside, not be the administrator in favor of the other person.
And I suppose that there's a possibility that there could be conflict and contests over who was going to administer the estate.
Absolutely.
Another good reason to have a will, I suppose.
Absolutely.
Right? Now, what are the typical clauses that you would have in a will? Let's start with maybe a simple will, because there's simple wills and there are complex wills. Let's start with a simple will. What should you have? What's
I
essential?
think there's three main clauses you should have in any will, whether it be simple or complex. The first is the revocation of any and all prior wills. What that means is when you execute a will, the first clause should say, I revoke all wills done by me heretofore or codicils thereto. So what that says, if you did a will 5, 6 years ago, 20 years ago, that will is automatically declared invalid by the execution of a new will.
Okay, let's stop there for a second. If you have an old will and then you go make a new will, is it a good idea to get that old will and rip it up?
I always say yes.
I do. I mean, in my own practice, I would rip it up so there's not a chance that they can't find the new will and the old will is still around.
That would be
right?
correct, yes.
That would be the reason to do that.
Yes,
Now, there are some attorneys that hold the wills in their offices.
that's
Right?
correct.
Is that one of your practices?
No, it's not normally one of my practices. I give the original will to the client and maintain a copy, and I usually put a business card with the original will and tell the client you should do one of two things with the original. Put it in a safety deposit box or a fireproof box in your home and notify the executor, because you're going to name an executor, and we'll get to that in a little bit,
Okay.
as to where the will is, the actual original will. And depending on who the executor is, you may actually want to give it to the executor for safekeeping, especially if you're an elderly person and maybe one of your children are going to be the executor. Let them hold on to it so that in the event of your death, it's readily located.
Okay, that's the first important clause.
Yes.
What's next?
The next clause is the payment of all your expenses, medical bills, taxes, anything associated with your death that's still hanging out there, so that your heirs at law don't have to deal with it. It's already directed to be paid by the executor.
In a general sense, we could have another show just on taxation. What is the general scheme of taxes? What taxes generally would apply to an estate?
There's two forms. Under the federal government, you have what's an estate tax.
Okay.
Currently, for the year 2009, the first 3.5 million are exempt before any estate tax would kick in. So probably a significant number of Americans right now are well underneath that they would not owe federal estate taxes. In New Jersey, there is estate taxes and inheritance taxes, which are two different things. The inheritance tax is a tax that is posed against the beneficiary. For example, if you're the beneficiary of a will, depending on the lineage from the decedent, you may be obligated to pay a certain amount. Spouses, children, grandchildren are exempt from inheritance taxes, but nieces, nephews, and third parties that are not related are not exempt, and they pay 15 or 16% inheritance tax under New Jersey state.
So when making your will, you need to be cognizant of the degree of taxation for each of the designated beneficiaries.
Correct.
Right?
Correct. And providing for that payment of taxes and expenses, etc., what that means is whatever would be assessed to the beneficiary, they would not be responsible for paying, but rather the estate would take their portion of the taxes out and pay it on their behalf before any bequest was received.
You hear that people have insurance policies to pay inheritance tax.
Correct.
Is that a practice that you recommend?
It really depends on the size of the estate. For people I usually generally see with about 600,000, 700,000 or less, I don't really see the need, because 9 out of 10 times they don't reach that limit that's imposed right now. But as you get up there higher, around 850,000 to $1 million, you're going to see where taxes are going to be a little bit more significant.
Okay. Let's move on to the other clause, because we could spend a lot of time on taxation. There are tax attorneys and accountants and consultants that create estate planning that really try to minimize the taxes in larger estates. But that's for another night.
And probably for an accountant as well.
Right, there you go. How about the next important clause that you would
The
recommend?
third and final clause that I always think should be in every will is what's called the residuary clause. That's sort of a catch-all, because when you do a will, sometimes you might make specific bequests. I give a certain dollar amount to a certain person or a certain charity. I give my family heirloom ring to my firstborn daughter, etc. If some provision that's a specific bequest fails, and that means that either A, the beneficiary is no longer alive, can't be located, or for whatever other reason under the will that it may fail, their bequest becomes unknown unless you have what's called a residuary clause. If that particular clause fails, it becomes part of what's called the residuary estate, and in the residuary clause you say any and all residue remaining goes to, and then you designate the beneficiary and what shares